Hello. We are still talking about the Constitution and specifically the basic principles that the Constitution is built upon. So, in the last video, we talked about popular sovereignty, limited government, and separation of powers. Today, we're going to get started by talking about checks and balances. We are reading from our old textbook, Holt American Government. You can go to the National Emergency Archives or the National Emergency Library, and you can find an online version of a newer edition of this textbook, but I'm going to be reading from this because it's what I have on hand. So we're going to start by talking about checks and balances. The Constitution also prevents the concentration and abuse of power by giving each branch of government the authority to check or restrain the powers of the other two branches. This system of checks and balances divides power within the government. Executive and legislative checks. The system of checks and balances forces each branch of government to consider the opinions and actions of the other branches. This is particularly true of the executive and legislative branches. For example, if Congress does not consider the wishes of the president when it writes legislation, the president may veto or reject that legislation. This veto power often encourages congressional leaders to meet with members of the executive branch to reach an agreement about controversial legislation before it's passed. For example, congressional leaders meet regularly with the president to discuss the federal budget. In some cases, however, the negotiations on legislation are difficult. The president's power to effect legislation is limited. However, Congress is able to override a veto if at least two-thirds of the members in both houses of Congress vote to do so. Congress also checks the executive branch through its power of the purse, for only Congress can approve spending by the federal government. Congress can, for example, limit or refuse to approve money for programs that the president wants. Congress also has checks on other presidential powers. The Senate, for example, can reject any presidential appointments to top government jobs. In addition, the Constitution states that international treaties negotiated by the president do not become law unless approved by a two-thirds vote in the Senate. These checks on executive power mean that the president must consider the wishes of Congress when proposing legislation, making appointments, and negotiating treaties. Judicial review. The judicial branch also has an important role in the system of checks and balances. While federal judges are nominated by the president and must be approved by the Senate, federal courts can check the powers of the legislative and executive branches through judicial review. Judicial review is the power of the courts to decide if laws and other government actions are valid under the Constitution. A law or government action that is found to violate any part of the Constitution is said to be unconstitutional. Because the Constitution is the nation's highest law, an unconstitutional law or act is illegal and cannot be enforced by the government. Keep in mind, however, that laws are reviewed only if their constitutionality is in question. Judicial review is not specifically mentioned in the Constitution. Section 2 of Article 3, however, implies that the courts have such power. The principle of judicial review was firmly established by the Supreme Court in the landmark case of Marbury v. Madison in 1803. In 1801, William Marbury and others were appointed to judicial posts by the outgoing president, John Adams. The commissions, or documents that formally gave them their posts, were not delivered before Adams left office, however. Thomas Jefferson, who had defeated Adams in the presidential election, ordered Secretary of State James Madison not to deliver those commissions. Without them, the appointees could not legally take their posts. Marbury asked the Supreme Court to order Madison to deliver the commissions. Marbury based his case on the Federal Judiciary Act of 1789, part of which stated that cases like his must be taken directly before the Supreme Court. The court ruled, however, that the Federal Judiciary Act violated the Constitution, which specifically listed the types of cases that the court could consider without a lower court hearing them first. Although the ruling meant that the Supreme Court could not force Madison to deliver the commissions, it established the broader power of the courts to decide the constitutionality of congressional actions. This power of judicial review allows the courts to check the power of other branches of government. The last basic principle of the Constitution that we are going to talk about is federalism. The Constitution is designed to protect the rights of the states by establishing a federal system of government. A federal system is one in which powers are divided among national, state, and local governments. In the U.S. federalist system, some powers belong to the national government, others to the state governments, and still others are shared by both. The way in which the federal system divides power along the levels of government will be explained more later. Although the framers of the Constitution wanted to protect states' rights, they also wanted a national government that had sufficient powers to maintain order and keep the country united. They had learned that a weak government, like the one that was formed in the Articles of Confederation, could not force states to obey national laws. Thus, the Constitution specifically prohibits states from exercising certain powers that belong to the national government, such as negotiating treaties, coining money, keeping troops or warships during peacetime, or engaging in war unless the state is facing imminent danger or invasion. In addition, Article 6 of the Constitution states that the power of the national government is superior to that of the state governments. This supremacy clause declares that the Constitution, along with U.S. laws passed under the Constitution and treaties made by the national government, is the supreme law of the land. So we talked about 5 basic principles in our Constitution. They are federalism, checks and balances, separation of powers, limited government, and popular sovereignty. So that wraps up the basic principles of the Constitution. I will talk to you guys later and hope to see you sooner rather than later. Until then, take care.